Aloha, and thank you for tuning in to our next podcast episode. Want to make sure you never miss an episode, as well as get tips on how to hire an attorney and be eligible for monthly prizes? It's easy. Just join our free membership called the Agent of Change membership. Text your name and your email to area code 808-670-3400. Make sure you text back agree. And also, to check out our past episodes, just log into www.legaladviceinparadisepodcast.com. Now enjoy the next episode. Aloha.
Welcome to the Legal Advice in Paradise podcast, brought to you by www.legaladviceinparadise.com. Even in one of the most beautiful places in the world, life can be litigious. On this podcast, the best and brightest legal minds gather to help you navigate your way through every legal question you may face. This program will help you know your rights, know what steps to take, and help you find the best legal representation, all in simple, easy to understand terms. And now, here's your host, Justine Gronwald.
Aloha, Agents of Change. This is Justine with Legal Advice in Paradise. Welcome back, and I'm really excited today because my special guest today is Susan Ichinose. And the reason I'm excited is she's our first woman legal expert on this show. So I just want to introduce you to her, and she'll tell you more about herself. She has a lot of experience.
Oh, Justine, thank you very much for inviting me on this show. And I've been practicing law now for 36, going on 37 years. And I started out as a commercial litigator, doing mostly antitrust, contract, and other types of commercial law in court. And in the late 70s, early 80s, I took a case on appeal, which was Parnar versus Americana Hotels. And it started the ball rolling on employment law cases.
Yes, which a lot of my listeners have been asking for information about that. Today we're going to touch more on mediation and arbitration, but do go on about it because a lot of people are so interested in that.
I took the case, and Parnar, the Supreme Court of Hawaii, ruled for the first time that an at-will employee could sue for wrongful termination.
That word, those two words, at will, that's...
Well, most employees in the United States are at will. Mm-hmm. That means you don't have an employment contract, you're hired at will, and you can leave at will. Mm-hmm. And so 19th century law going into the 20th century throughout the country was that at-will employees really had no right to sue. And even today, your causes of action for wrongful termination or employment injuries are limited.
Yes, so, because I went through my own case, and at-will came up a lot.
Yeah. Unfair. Mm-hmm. I've had a lot of people over the years come to me with clear cases of being treated unfairly. Mm-hmm, mm-hmm. But unfair treatment of an at-will employee is not necessarily...
It's not a cause.
No. You can sue for things like discrimination on the basis of several protected categories like race and sex.
And religion and all that stuff.
Yes, and you have the right to get work comp for injuries on the job. Mm-hmm. You can sue for breach of contract if you have a contract, but then it's likely that you're not at will.
I had a contract, and the judge deemed it as silent or ambiguous, and he signed it and everything, and I lost on that claim.
But who wrote the contract?
We did.
Was it mutual?
It was mutual. He signed it. He even initialed it, made changes, and agreed upon it.
You see, most employment contracts are written by the employer.
Well, this was more of a commission basis type of thing.
I see.
So it wasn't, But anyway, getting back, you should always have an attorney draw up any kind of contract.
Well, at least have an attorney review it.
Yeah.
I know that it's difficult for many people to even contemplate getting an attorney for things like reviewing a contract. But, you know, there are times when you really do need a legal mind to review something.
Because if it goes to court, it needs to hold some water.
Right.
Really. Yeah. I learned a big lesson on that one. I'm glad that you're bringing all of this up. And I've definitely been getting questions from the listeners and the audience through Facebook, through email, that they want to know about this stuff. Because, you know, first of all, it's hard to get a job today. And second of all, it's like some of them feel they've been treated unfairly, but if they leave the job, where are they going to go? Do they continue living, you know, working under certain circumstances? I know we're getting off here from what we really wanted to talk about, but I think this is so good, like whistleblowing and stuff like that.
That's what Parnar was. Parnar was a whistleblowing case. She had the right to sue, according to the Supreme Court, for a wrongful termination in violation of public policy because she refused to do what her employer wished her to do, which was to go along with an employer's defense in an antitrust case. So,
in her good conscience.
Well, what happened was that she was interviewed by the company lawyer about an ongoing antitrust case being brought by the Justice Department.
And this can be found online, right? Because it's
a Supreme Court opinion.
Yeah.
Yes.
Okay. Yeah.
And she didn't want her boss to sit in on her interview. She thought it was confidential and she was going to tell the truth.
She didn't want to be biased.
Her boss wanted to sit in and make sure that she didn't communicate certain information.
Right, obviously.
And what happened was that 30 days later, she found a pink slip in her pay envelope.
Oh.
And she was terminated that day.
No
without
warning.
Notice.
Wow. That is harsh.
Yeah, so she lost
may
her
I ask
case.
You how long was she working for that company at that time?
It was several years.
Wow.
But thereafter, it took about 10 years for her to finally achieve a judgment in court that was upheld on appeal. So, employment cases...
They take a while.
They take a while, which gets us to mediation and other forms of alternative
but
dispute
you know what?
resolution.
I am so glad that you brought that up because it's out there. People want to know, right? Like you said, what's the cause? It can't be because it's just unfair. It has to be based on law, not because you have hurt feelings or your boss is a tyrant. None of that counts.
No, unless, well, your boss can be a tyrant. And if he's a tyrant to everyone, of every race, of both sexes or other sexual orientations, then I don't know that you have a cause of action except for injuries suffered on the job, and then you get work comp. Because that's basically your only resource.
But if he targets you and you're the only one that he pretty much terrorizes on a regular basis, that could be cause?
It could be, but it has to be due to certain unlawful bases. Like, is he targeting you because of your race?
See, in my case, I was married to him once, but I stayed on the company, and he also, I was suing for sexual harassment because he felt it was ex-husband rights that he could still continue to touch me. And of course, when he went up on the stand, he lied about it when my attorney asked him those questions, and he straight out lied. But whenever he would touch me, he would say, well, I have ex-husband's rights, so, So he would justify his actions, and I'm running his company on a day-to-day basis, and I would keep telling him to not do that. In fact, I got remarried at that point, and I couldn't say that to people. You know, I couldn't disclose that to my husband at the time because that would just. But anyway, that was my case, and I'm pretty sure there's a lot of different things I could have done differently. But you know, I had 5 claims: sexual harassment, breach of contract were a couple of them, and I lost on all of them.
Oh.
Yeah, and I think if I did things differently, definitely I think I would have a different outcome. But I'm glad you shed light on it, because people should know that, you know, you might have a lousy boss or you're just unhappy. That's not cause. So people need to know that.
Yes, and we have to clarify that at-will employees are not the same as, say, union members who are covered by a collective bargaining agreement. A collective bargaining agreement gives you certain rights as a union member, including the right not to be treated unfairly. So there may be causes that you can...
But that's only under a union.
Right, under a collective bargaining agreement.
And that's why you pay those dues.
That's right.
So this is great. We're gonna segue into what you do today, because you're not a practicing attorney per se, but you're more of what we're gonna discuss, a mediator, arbitrator, and you're also an expert witness. So maybe if we could touch on that and how that comes into play for someone who has a possible case or looking to file a claim or any of those things. So I'm just going to let you take it away.
Well, you've given me a lot of ground to cover. It's been, it's been a long time for me in practicing law. And for most of my career, it's been a battle. As a litigator, I can tell you that for over 30 years, I've had to fight in court and in arbitrations and other proceedings for the rights of my clients. And I've represented both plaintiffs as well as defendants. As a commercial litigator, usually
it's the defendant.
You can do plaintiff work or defense work. You know, a company can sue for breach of contract, and therefore the company is a plaintiff.
Right.
The company defends on breach of contract, the company is a defendant.
Right.
And they both need commercial litigators usually. So I did that for law firms that I was with for over, I'd say, 15 years. And then I joined another lawyer in forming an employment firm, a boutique firm for plaintiff employees to sue. But what I learned from that was that in the employment area, generally speaking, you're either on one side or the other. You either represent plaintiff, which is employees, or you represent employers, and that's because philosophically, they occupy different parts of the litigation world. And so I came to be identified with the plaintiff employees rather than being able to segue from one plaintiff to a defendant.
I would think you're like the heroine.
Well, no,
because people are looking for representation as an employee.
Well, that's true, and so I came to be identified with the plaintiff side, and I was also doing arbitration work as an arbitrator for the American Arbitration Association for Keith Hunter, who was then head of the office here. And I became intrigued with alternative dispute resolution, where matters are generally governed by neutrals. So rather than take a plaintiff side or a defense side, you occupy a middle of the road.
You're like the referee.
And you facilitate communication and hopefully resolution.
That's great.
Between the two opposite ends.
Yeah.
And so I decided to become my own solo practitioner in 1999 because I wanted to start concentrating on ADR, which is alternative dispute resolution, rather than become identified with just one part of the bargaining table.
Right, right.
So 1999, I started a solo practice, continued to litigate, but became more and more involved over the years in alternative dispute resolution. I joined Keith Hunter's burgeoning enterprise.
He's always busy, Keith.
Right.
I've known Keith for a few years.
So I'm now on the panel of dispute prevention and resolution, which is a local ADR concern.
And that would be DPR. And this is where we're conducting our interview, and they were nice enough to lend us a space for us to talk.
Right. And I do work on my own as an occasional expert witness, an occasional workplace investigator, and things along that line.
Wow, interesting.
Right. It is interesting.
It's like being a PI all at the same time.
Yeah, I don't know about that, but yeah, it is very interesting.
Yes. You get to look under the rock and see what's left in there. What can lend to this? You know, what can bring light on the whole thing?
Well, you know, under the anti-discrimination laws, employers are almost obligated. In fact, they have a duty to investigate when somebody makes a claim of discrimination or harassment. And that's because what the administrative agencies who enforce that law, the EEOC, and in Hawaii, the HCRC, Hawaii Civil Rights Commission, what they want is they want the employers to help them administer the anti-discrimination laws. They want to make it a mutual concern rather than an us against them. And so they have promulgated regulations that have employers create policies in the workplace against discrimination and harassment, and they have employers enforce those policies by investigating claims. And sometimes they use, you know, supervisors, sometimes they use trained HR people to investigate. And occasionally when the matter is a little more complicated than the usual, or maybe involve top managers that would be difficult for internal people to investigate, they can contract for independent or private
that's where you come
investigators, and that's when I do get calls. But you know, it's expensive for the company. It sort of puts them on a limb, because when it's a neutral investigating, that you have to pretty much observe what the neutral has found. So it's a best employment practice. And I get calls now and then.
So at what point are you called in? Say, let's take for an example, what would be an example of a case where you would be called in to mediate or be alternative as opposed to going to court?
Well, I can tell you that mediation as an alternative to litigation really has hit its stride only in the last decade.
That's good to hear, though.
It is good because initially, when it was posited as an alternative to litigation, I can tell you, I, as a litigator, thought, if I agree to mediate, that's a sign of weakness.
That's exactly what I was thinking. You know, that would be like, okay, I can't handle this, let's give it to a mediator, when really it's the best for everyone.
I think my case is weak.
Right. So that's probably why a lot of attorneys don't mention it, but
that was many, many years ago. And it has come to be accepted now as a desired alternative to litigation, because it is not a sign of weakness. In fact, it's written into the state court, circuit court rules that attorneys have to discuss the prospect of mediation or some other alternative dispute resolution mechanism.
This is a nugget that I want the listeners to take away, is that if you're going to hire an attorney and it has a feel that it might end up in court, he needs to disclose this to his client?
Well, you need to discuss it with the client, and you need to discuss it with the other side.
Okay.
And in circuit court, the rule is that you need to discuss this, and you need to have a meeting. It's also in the local federal court rules. So the U.S. District Court has local rules that call for the parties to meet and confer.
Okay.
And one of the items they must meet and confer on is alternative dispute resolution.
Wow, because I don't, for me, this my case was a few years back, and I really don't recall that ever coming up in the conversation. I remember when initially sitting with my attorney, he said, "You got a good case," and I wrote him a check, and we all know that for those listeners that have been following, I lost. But I had the good fortune of, at that time, I got to talk to Keith Hunter. Although it didn't go into ADR, he would just discuss my case at length, and it was never brought up that this could be. Now, when we got to the point of, for those of you who've been to this, we did do depositions. When we finally got a court date, we did do, they met with the judge, and we could have done a settlement. Now, that's different than mediation at that point. That's way beyond mediation at that point, the settlement.
The settlement conference with the judge, if it was several years ago, it would have been done maybe 2 or 3 months before trial.
Oh no, this was done on the spot. I mean, we already had, I think, 1 day in court, and then they said, okay, we're going to try and do a settlement.
You mean you were in trial?
Yeah.
Before you had a settlement conference, you were in trial?
Yeah, we did 1 day in court.
Is this in circuit court, or?
Yeah, but this is like totally coming on.
That's unusual.
Well, I think a lot of my stuff was unusual, and if I had the knowledge that I have now, speaking to legal experts such as yourself and other attorneys that I've been talking to, it would have been, like I said, a whole different outcome. But getting back to doing the alternate of mediation, that's something that the attorney needs to bring the two parties together, right? You're saying?
Well, the neutral. Well, let's take mediation.
Okay.
Very different from arbitration. Arbitration is basically a way of resolving your dispute through a private judge. That's what an arbitrator is.
Okay, that's different.
It's started out decades ago as a simple way to resolve contract disputes.
Okay.
And it has evolved into a court substitute for all kinds of disputes. You have to pay for your private judge, unlike court. And the concept behind arbitration is that you're going to be able to do this quicker, probably cheaper, but in all likelihood, you will never have the right to appeal.
Oh, so that pretty much gets rid of an appeal.
I would say everybody who has a bad result in arbitration always considers appealing it. And most of them do more than consider. They take steps to do it, but it's very difficult to get an arbitration decision appealed.
I see.
It has to be for things like conflict of interest of the arbitrator, where you are prejudiced by a a less than impartial judge, things like that.
So you really got to think seriously prior to going.
Well, a lot of employers have arbitration provisions written into their handbooks, their employment contracts, because it's, number one, it's private. You don't face the prospect of publicity or a court action.
And it won't be found on hoiiki.org. It's different.
Well,
it's not open to the public.
Private arbitration is usually not open to the public. There are exceptions, particularly when the arbitration, well, you have lawyers, of course, and there's no gag rule. The lawyer can do whatever in the public arena with respect to that. There have been cases where, although there was an arbitration agreement, the lawyer for the plaintiff has brought a court action, then the defendant goes in and compels arbitration instead of court action. Things like that do occur. And it's not unusual. But I'm just trying to explain what an arbitration is.
As opposed to mediation.
Yeah, mediation is sort of like an adjunct to arbitration and litigation.
So it's like a...
You can use it in either.
Yeah, okay.
way.
I see what you're saying. Okay.
Mediation is somebody say, have you ever considered the possibility of us negotiating a resolution to our dispute? Now, I've said that in court rules, they mandate that the attorney must do this.
Yeah.
And sometimes it works and sometimes it doesn't. Many times, maybe it's too early. You need to do some kind of deposition or other discovery.
So it's up to the discernment of the attorney to see when it's the right time. Like you go through depositions, and for those of you who don't know what depositions are, it's when the plaintiff and defendant come together.
It's a witness giving testimony on their own in a private office rather than in court.
Right.
And it can be a party to the case or just a witness in the case. And it's as if you're testifying in court, except you're doing it in a small conference room like this.
Right.
Or sometimes it is held in a courtroom, but that's rare. It is usually done in a private.
It's a private. There's no judge, and there is. What is that person that takes the notes?
Oh, court reporter?
A court reporter is there. Okay, yeah. And then all those records are taken
prior to court. Right.
Yeah, okay.
But that's what discovery is.
Discovery.
Discovery is one side trying to discover what the other side has.
Right.
And you can use document requests. I want all of the contracts that you have between you and my client. I want to have the personnel files of so and so and so and so. Things like that. That's written discovery.
Yeah.
Or I can ask a question in writing and have them respond 30 days later and say, how many lawsuits have you been involved with? And they will answer in 30 days. That's written discovery. But oral discovery is a deposition where you get a chance to ask questions of a witness in a room, face to face. Sometimes you can do it by phone. Or on closed circuit television. But yes.
Wow, that's good to know.
You can do that.
Thank you for listening to the Legal Advice in Paradise podcast. For more information, visit www.legaladviceinparadise.com.